Okay, good afternoon, everyone. I would like to, first of all, to give my thank you, Professor Vio and Susanna, for letting me to be here and to talk about our problems in shipyards and nautical tourism ports. So all of these days, we are talking a lot about mass vessels and about mass ships, and maybe also we will talk in near future about mass yachts, maybe. But today I would like to go a few steps back where everything began. And everything starts in ports. So in Croatia, we have special purpose ports like shipyard ports and nautical tourism ports, which are under the concession contract. And they are under the directive on the award of concession contract. So today my topic is for ports of special purpose and the challenges they face in the context of European regulation on sustainable business. So we have here 3 agreements which are crucial for ports of special purpose who are in the concession and also for the other companies. This is the Paris Climate Agreement, European Action Plan on Sustainable Finance, and European Green Deal. So in 2016, Paris Climate Agreement came into the force, and he had a few goals. The first one was to limit global warming under 2 degrees and to put the efforts to increase that on 1.5 degrees. The second was define the consequences of climate change. The third, which is the most crucial for the nautical tourist ports and the shipyard ports, is developing new green technologies and to help and support to less developed member states to implement their into the directives and obligations under the European laws to the national laws. In 2018, European Action Plan on Sustainable Finance was adopted and came into the force, and his main goal was to redirecting capital to sustainable industries. So the answer how to do that was given by the EU taxonomy regulation for sustainable activities. It's a classification which gives us the answer which activities are sustainable and environmental friendly. And so it's a classification and helps to the investors to invest in that type of industries their money. The second was to define and systematize sustainable risk management. The answer how to do that was given by the Sustainable Finance Disclosure Regulation. And the third, the most crucial one, was to define corporate behavior. And the answer how to do that was given by the Corporate Sustainability Due Diligence Directive, which came into the force in July this year. It's also called CS3D Directive. So in 2019, European Union decided that she wants to be a leader in fight against climate changes. And she said, okay, we will try to reduce the emissions for 55% in accordance with 1990s. But she said, okay, we will not do that. The companies and the private sector will do that because they are the crucial initiator of necessary changes. And she said, okay, how they will do that? By the ESG standards, which they will report. So they need to harmonize all their standards which they have. How will they do that? By the CS3D directive. And where they will report? Under the CSRD directive. So when we are watching the CSRD directive and the CS3D directive, we see the criteria. So in my case, in my company, when I put all the conditions on the paper, I said, okay, we will implement CSRD in maybe 2027-28, but we are not under the personal scope of CS3D directive. But then I saw one provision into the CS3D directive, which says contracting authorities and contracting entities may exclude or may be required by member states, exclude from participation in a procurement procedure, including a concession award procedure, any economic operator. And that I was asked myself, am I any economical operator? And the answer was positive. And in that case, I was wondered, am I obligated to implement CS3D directive directly into my company? Okay. So if the answer is positive, so which are the specificity of CS3D directive? The CS3D directive, she has a catalog of conventions which include human rights, and also a catalog of conventions who are included into environmental instruments like MARPOL. And the second specificity is that for the first time, the European Union said, yes, but member states are not doing enough to harmonize their law by the directives, etc. And she said, we will take the principle of subsidiarity. So the companies who are in the personal scope of the directive, they must directly apply all the provisions from the directive. So in that case, if I'm concessionaire and if I can be excluded from the contract, and I have the obligations to take measures and results for which arise for me in 2025 based on the financial statement in 2024. Okay, I was wondered if I have a new concession contract. The Article 31 says that it may be appropriate to consider rules in the CS3D directive when the concession grantor is giving the concession under the directive on the award of concession contract, which in Republic of Croatia is included into the Concession Act and Seaport Act. And in that case, I was wondered if I will be in the same position as the other party who is maybe included into the personal scope of the directive. And I think that I will not. So in other words, I must implement, even I'm not in the personal scope of the directive, I must implement her into my business activities. So which are the obligations of concessionaires? They must take due diligence process, and it should cover 6 steps. So the first one is integrating the due diligence into all relevant policies and risk management system. How to do that? So I will talk with the employees and the representatives. We will make the description of company's approach. We will make a code of conduct, which describes rules and principles, and I must update it every 24 months. Then in the second step, I must identify all actual and potential adverse impact. How I will do that? I will map the operation in order to identify where I have negative impacts. In the third case, in the third step, I will try to prevent or minimize the negative impact. In the fourth step, I will monitor the effectiveness of the measures. I will communicate with the reports and put it maybe on our website. And I must, in the sixth step, provide a remediation. So if I must make a report, I will do it under the CSRD directive, but it's for me, I think this is the same to the step 5 of CS3D directive. And this is the factors I must inform, in which I must inform. So when we have the existing concession contracts, in Croatia, our concession contracts are given under the Seaports Act from 2003 and even earlier. And in that period, even the CSRD and CS3D were not known. So the paragraph 52 preamble of the directive on the award of concession contract, he said that the time of granting the concession under normal operating condition must be known in the time of giving the concession. and the time will be prescribed in the study of the economic justification of granting the concession. So in that case, if the Paris Climate Agreement says you must make a turnover in your investment, and I'm in the third decade of my concession when I want to make just the profit, now in the moment I'm obligated to make new investments and to adapt new regulations and make new infrastructure and everything, for example, for mass vessels. And my question is, have I the right to extend for the concession? So this, I think that I have, and this will be my CSRD and CSDDD will be my main reason for asking for the extent. So what are the consequences in case of violation rules? The Parliament's suggestion at the beginning was that supervisory authorities are obligated to revoke the concession from the concessionaire. But in the end, today we have the final provisions, which says that sanctions are at least monetary, 5% of net income. But that doesn't mean that the authorities cannot exclude concessionaire from the concession contract. So here I had one question. So if I or my business partner have made a violation of the directive, CSDDD, but I also put all my efforts to carry the damage or to put it on the minimal possible extent, will I also be excluded from the concession contract? So that's something that also I think that we will see in every single case. So for the end, is CSDDD direct or indirect applicable on small and medium enterprises and which are concessionaire? I think that is direct applicable. Why? Because the term any economic operator in concession of art procedure includes a wide range of subjects, which also includes me. When we have a value chain, I have business partners like, I don't know, Meyer in Germany, who is under the personal scope of the directive, and he will say, okay, give me the guarantees that you are doing your best, that you are respecting the provisions of CSDDD directive, because otherwise he must pay the penalties, because he must controlling me, and he will probably ask me some guarantees, maybe bank guarantees or something. And also in Nautical Tourism Board, I have my business partner, and I also must control them. And for the end, the third reason why I think that CSDDD is also direct applicable, because it says that from 2030 and every 3 years, there is an obligation to consider that the CSDDD may include lower threshold, lower number of employees, and lower net income. So in the end, we all be included with CSDDD directive. So for the end, I think that any economic operator is this little guy, and the bear is European Union celebrating its Paris Climate Agreement. So thank you for your attention.